Newsome. I'm an attorney at Constangy Brooks Smith Prophete, and we're presenting this presentation entitled Back to Business, Business Operations and Legal Liability Part 2. Mel Hayes, partner and managing partner of the Macon office of Constangy, is joining me. You'll hear from him in just a little bit. And today we're going to talk about three main pieces of legal liability and issues that come up due to COVID. That's the big hot topic right now. I know a lot of you are probably interested in hearing about it. So that's really what we're going to focus on today. So the first part is COVID liability legislation. And if you tuned in for part one, you'll remember that I mentioned legislation possibly at the federal level. And in the meantime, there's actually been legislation enacted and passed and signed by the governor here in Georgia. I'm also going to briefly talk about payroll tax withholding memorandum from President Trump that came out about a week or two ago. I know there are a lot of questions about that. There's not a lot of guidance out on that yet, so we're going to kind of talk about that to kind of give you some ideas of where to navigate and steer next. And then Mel is going to talk about recent rulings from the National Labor Relations Board. And these are important for all employers, not just for those who are unionized. These rules and rulings affect every employer in the nation. So let's get started. So in Georgia, there are a lot of other laws in other states that are similar, but Georgia, the legislature back in July passed the COVID-19 Pandemic Business Safety Act. It was a bill originally sponsored and written by Chuck Huffstetler in Rome. Sorry, my pronunciation on that. And the Senate passed the bill mainly along party lines, but it did pass. It was a measure that was supported in both chambers, especially given the presence or lack thereof of any legislation at the federal level that would enact protections for employers against COVID liability. And that's exactly what this bill does. It protects businesses against liability for certain claims relating to COVID. And we'll talk more about that in just a moment. It was signed by Governor Kemp last week, or 2 weeks ago, pardon me, on August 5th, 2020. It took effect immediately upon signing, and you can Google it. It will be codified at OCGA 51-16-1. As of right now, it hasn't been added to the code, but if you just type in a quick Google search, it'll come right up if you want the actual text of the bill. So the substantive provisions of the law include a provision that no healthcare facility, provider, entity, or individual, so those include other normal businesses and also healthcare facilities, mainly hospitals, home care providers, and things like that. They won't be held liable for damages in an action involving COVID liability unless the claimant proves that the actions of the entity were grossly negligent, willfully, or wantonly involving misconduct, reckless infliction of harm, or intentional infliction of harm. So what this means in layman's terms is if an employer or business is negligent, just plain negligent, the law blocks that bill. So a plaintiff would have to prove that a business or an entity, an individual healthcare provider or facility, they were grossly negligent. And so what that means is they would have to show that the individual knew there was a risk and recklessly disregarded that risk. So take, for example, the following situation. An employee comes to you and says, I've tested positive. I still want to come to work. I don't have any symptoms. I probably won't infect anybody. You as the employer, if you know that that person is positive, they have COVID, and you allow them to come to work, that would be gross negligence. And it would actually be arguably willful and wanton misconduct as well, because you're subjecting your other employees to that risk. You know there's a risk there. You know this person is positive, and you're not doing what you should do to protect your employees. So that would be an example. Now, compare that example with this. So an employee comes in, they've tested positive for COVID. They don't tell you, okay? The employer has no way of knowing, okay? Maybe you're negligent. Maybe you should have asked if they were positive. Maybe you should have done screenings, things like that. But one of your other employees gets sick and they sue you. Now, were you negligent? Sure, you didn't institute safety screenings. Maybe you weren't having your employees wear masks. Maybe you weren't doing a lot of the other things that the CDC and other governing bodies have recommended. This bill would protect you from liability if you were only just plain negligent. Okay, if there's any other level or standard above that, it would not protect you. So if the employee who got sick can show that you were grossly negligent, the bill won't protect you. Now the bill, it does have some requirements for you to get this protection. Okay, I'll talk more about those in a minute. I'll summarize this slide briefly. really it just protects against all COVID claims. If an employee gets sick, so it's transmission, infection, or exposure. These are just the different standards. Again, these are in the text of the bill, so you can find them. I won't spend much time on those. And the bill also provides a rebuttable assumption of a presumption of the risk. So when you provide a receipt or proof of purchase for entry into your premises or business, okay? And so it has to be in at least 10-point Arial font, and you have to say, any person entering the premises waives all civil liability against the premises owner and operator for any injuries caused by the inherent risks associated with contracting COVID at public gatherings, except for gross negligence, willful and wanton misconduct, reckless infliction of harm, or intentional infliction of harm by the individual or entity of the premises. What does that mean? Really just includes what all I just said. Essentially, if you know by going out in public, there's this risk that you can get COVID, okay? Every business I've been into is taking some precaution, whether it's temperature checks, screenings, masks, social distancing, things like that. So essentially, you're assuming the risk by going out in public. You understand that there is a percentage of risk that employers and businesses here and across the world, they just can't protect you against. And so basically what this does is acknowledges that. And so if you've noticed, I've bolded receipt or proof of purchase for entry. And what that means is if you give someone, a receipt, if they buy something at your shop or your store, you can have that printed on there. One method that we suggested, if you were at the last presentation, you'll remember that we discussed COVID waivers. That's also a possibility as well for individuals entering the store. We've actually seen that across the state. Those have started to become enacted. Also, the rebuttable presumption is available if you post a notice at entrances to your location or your premises. So it has to be in 1 inch, and that's 72 Arial font. And basically it just says there's no liability for an injury or death relating to the inherent risk of COVID. And again, this is going to be that just normal negligence standard, okay? And again, you'll want to post this. I know places around Atlanta, Macon, I've already seen them posted. Usually they're right beside the door, right on the window. So if you haven't got those posted, be sure you do already. That way you can get the protection of the new law. As I mentioned, this law is similar to others passed in other states. And again, it only applies to claims of regular negligence. It only applies to cause of actions that accrued before July 14, 2021. That could be extended depending on the shelf life of COVID and how long this goes on. But as of right now, you'd have to get sick or have some kind of damage before that date. All right, I'm going to move on to the payroll tax deferment. We'll save any questions to the end, so if you have them, just write them down and remember them. 2 weeks ago, President Trump issued a memorandum deferring payroll tax obligations due to COVID. I know this has been a big one for employees, especially since the extended unemployment ran out. And also many employees, they've already gotten their stimulus, the CARES Act payments. So some extra money in their pocket, certainly something they're concerned about. And basically what this memorandum does, it allows the deferral and withholding of deposit and payment of payroll taxes beginning on September 1st, so next week, I believe, through the end of 2020. Now, the memorandum, you can pull it up if you go to the White House website. It's fairly easy to find. If you can't find it, email me and I'll be happy to send you the link. It's pretty short. It's pretty basic. There's not a lot to it. But what there is, so like I said, it allows employers to defer payment of payroll taxes, but it only applies to employees whose income is generally less than $4,000 on a biweekly basis. Comes out to about $104,000 a year. Now, I'll talk more about that generally less than, but so it's not all employees. Generally employees making over $100,000, they're not going to be eligible. So as you see, I mentioned the generally less than. It seems like there's some room for ambiguity in there, and maybe some other employees who make over $100,000 could be covered under the new memorandum and be allowed to defer their payroll taxes. I'll get more to that in a minute. The memorandum, and I'll go ahead and move it to the next slide. It requires the Secretary of the Treasury to promulgate rules and regulations to enact this, similar to, if you were in our last discussion, the Department of Labor, when the Family First Coronavirus Response Act was passed in the CARES Act, it directed the Secretary of Labor to promulgate rules and regulations. And so it's similar to that. As of right now, there's not a lot in the memorandum, as you'll see once you read it. And so we're really kind of waiting and seeing what the Secretary of the Treasury decides to enact as far as regulations. There could also be future federal legislation that preempts the memorandum by itself. So again, you've got a week or two before you have to take any or can take any action. So right now, we just kind of recommend waiting in a holding pattern just until the Treasury has given us some guidance on that. And I think I've already gone through all this. One big point is there hasn't been any effort by either really political party to drop or, stop President Trump's memorandum. Not sure if there will be, but again, the federal legislation I mentioned, if there's any in the future, it could preempt it. So again, just right now, we recommend just being aware of the bill, doing weekly searches or updates just to be sure that you're abreast of the law, and just right now staying in a holding pattern. All right, I'm going to turn it over to Mel Hayes, and he's going to talk about some issues before the National Labor Relations Board.
Good afternoon. We talked last time about concerted protected activity, and so the little known concept protected under the National Labor Relations Act, where employees complain about what the best way to describe it would be, it's a shared workplace complaint where employees complain that there's an issue that affects several people. If it's an individual gripe or a personal complaint or just dealing with an individual, then it's not protected as protected concerted activity. But a single person can engage in protected concerted activity if they're acting on behalf of other employees, they're bringing group complaints to the employer's attention, trying to induce group action, or seeking to prepare for group action. So much depends on that when you're dealing with a safety issue, which we're focusing on, and a safety concern or complaint cannot be concerted activity when the employee is just talking about its impact on that single employee. But if an employee has any coaching, well, they'll know that they need to couch it in terms of a group complaint. However, even protected concerted activity simply subjects an employee not to termination, but to being permanently replaced or temporarily replaced at the option of the employer. The more significant provision of the Act is Section 502 that allows a company to terminate someone, prevents a company from terminating someone if they're involved in an abnormally dangerous working condition. And that's an objective standard.
Okay. I found it.
That's an objective standard and gives a person complete protection. They cannot be treated as a striker and replaced. And OSHA has a similar provision as well. So what's happening is that the various fact situations are coming up, and the NLRB is finding them to be not protected when they're an individual gripe, and there's no desired change made requested by the employer. In other words, initiating a particular group action or complaint, as opposed to just simply making a complaint with employees talking back and forth, but not trying to induce any type of group action. And there's a whole list of different cases that have come up that under protected concerted activity, that many deal with an employer's work rules and the board has gotten significantly more pro-employer with regard to those cases. The most maybe glaring is a company now can have what's called a civility rule. That is, a person can be discharged if they behave in an uncivil fashion. And there is one case that was out of it wasn't a decision, but it was out of the general counsel advice section, where an employee was discharged for requesting that he be allowed to work from home and not report to work. And this the question was whether this request qualified as protected activity, and the board said it was not protected activity because the employee's request was purely individual, and that's about this pro-employer decision as we've seen out of the general counsel's office. I've been doing this for 40 years, and that's the employers are fortunate to have the approach of the NLRB now. So most companies are reevaluating their work rules and setting, but there are limits. For instance, there was another recent case on the other side where a company attempted to take disciplinary action because an employee was stopping another employee from complaining to the company, and they said that went over the line, that employees have a right to make complaints. So do we want to take some general questions at large now?
Well, Mel, I actually have a question for you. If you, the previous slide, I already forgot the company name, but the one where the employee was discharged for making the request that he or she worked, yeah, Larry Peel. Thanks, Graham. So as I'm reading this, am I oversimplifying it by saying that had the requester, the employee, included the interests and concerns of others in his request, the outcome may have been different?
You're exactly right.
Is that simple?
It's that simple. And the board in years past has found a lot of safety complaints to be inherently concerted because they, by the nature of the complaint, affected other people. In his complaint, he was asking to work from home, and I guess, and there wasn't any evidence that other people were going to be impacted by that. But most safety complaints, occur in the context of, there's ammonia on the floor in the facility, and 10 other employees are going to be impacted by it, even though just one employee, has filed a charge. That would be concerted. They would infer a concerted nature to the complaint because it involved other people.
Okay, I understand. Wow. Okay.
So I have a question, and it goes back to the topic of payroll taxes in the current executive order that the president signed. So companies don't need to start keeping that out come September 1. Keep business as usual, paying your payroll taxes, because nobody knows where that topic will end up. Is that correct?
That's correct. And let me explain why. So the memorandum, if you'll read it, it's a little unclear. It's not clear if it requires employers to do so or if it's actually, something they can do voluntarily. So again, September 1st, today is the 19th. Like I said, we anticipate some kind of guidance at least before or on September 1st, because the memorandum, I can send it to you. There's not much there and there's not a lot of guidance. So if employers willy-nilly just kind of choose to do it on their own, they may not do it correctly. There may be other computations that the Treasury may require, before it's done. So right now, we just recommend holding off. We've had some clients maybe who have started thinking about what they're going to do, and that's fine. But as far as taking any action right now, no, we definitely don't think you should do that until there's more guidance out there and you know exactly what you're doing.
Okay, so my next question has to do with I forget what the posters. Are they considered liability posters? Is that what those are called? Can you
Sure.
go back to that slide
Sure.
where you had that? Because I know a lot of people are not using them. I've seen a few. I'd love to know if anybody on the call currently has posters that they are displaying. But what you're saying is if you don't, it'd be a good idea to start putting that out there.
Correct. If you want the protection of the law, that's one of the ways to do it. As I mentioned in this slide, you can do the receipt or proof of purchase, could also be a liability waiver. But I think a good one to have is right there in the entrance when you're coming in. I mean, when I saw it, it didn't dissuade me from going in. I understand that, you know, I'm assuming the risk by going out in public. I mean, I have to go to the grocery store.
They have it in our building.
Yeah, I think they do. You know, so there's no way to be 100%.
We advise them to do that.
Okay, so Mel advised them. So yeah, I would recommend doing it, you know, sooner rather than later. Just that way, it's just an additional protection for businesses and employers.
So do you have a sample poster? Is this basically the language that is somebody, I know, I want to say one of our printers or a few of them have sample posters. Susan, I don't know if you've looked at a few of them. But this is probably something we should encourage our members. One of the first things is if you don't have your poster up, here's what you need to do.
I would encourage your members to have one, except when the chamber visits them.
There's a disclaimer. Yeah. No, I think it would be a valuable service to our membership to just go ahead and take this language directly and just create that sample poster. Let them download it as they see fit and make it as easy as possible for them to get these up, because I don't see, correct me if I'm wrong, Graham, I don't see any particular business that is, this is negated for, right? This applies to everybody.
Correct. And so this language in there is directly pulled from the statute. So it's exactly what the legislature crafted and enacted. Just want to make sure they're really particular about the 1-inch font. I guess it's just so it's visible and noticeable when you're entering the premises. That's 72 points. So just be sure. They also set out the Arial, that specific font selection. Okay. I'm not sure why. That wasn't something I picked. You know, just to kind of keep in line with exactly what the law says, I've been recommending that you use 72-point Arial font just down the road. You don't want, you know, to get called out on technicality. So
right. Okay, so I'll make a note to go ahead and get that done. And, you know, somebody asked, I assume it will be okay. Will you share this presentation with me so I can share Absolutely. It with members? Yeah. Okay. And then if anybody else has any questions, go ahead, Candace.
I do. So, and Graham, you might have gone, it was in the very beginning. Mm-hmm. What has substantively changed in the governor's, I guess it's executive order from June 12th timeframe to what he did this past weekend?
Sure. So one of the biggest things, and I'm sure you've all seen it on the news, the lawsuit that the governor was engaged in with the mayor of the city of Atlanta, that's arguably one of the biggest changes, is that now cities actually can enforce their mask mandates. You know, Atlanta had one. I know Athens had one. I know some other cities did as well. And it was a little bit unclear whether or not they could be enforced just because of the governor's orders, prior executive orders, and the lawsuits. So that's one of them. As far as the most recent, it's just a little bit more of the same: social distancing, wearing masks, sanitizing, disinfecting. I haven't seen it get as restrictive at a lot of other states. We had a large client who was doing like a survey, a daily survey of all the state and local executive orders that were coming out. So I've seen some pretty restrictive ones. Georgia's is, I think, reasonable comparatively, especially with the mask mandate. I think now that gives cities and local municipalities the control that they need just to, you know, stop the spread. Mel, do you have anything to add to that?
No, I mean, yeah, of course, the mask thing is a big issue, but you know, we were talking earlier about other on the continent. I mean, they're very strict, and for instance, only allow one. They initially, for years, didn't. I mean, for months, didn't allow any grandparents to visit their grandchildren. Now they allow one. I mean, so our rules are quite lenient compared to Europe.
I'll just add too that I think one of the other facets that's pretty much remained constant is the capacity limits for businesses and bars and restaurants and things like that. Those haven't really changed. I think they're generally capped at, maybe it depends on the size, but around 75 or 100 people, depending on the size of the venue. For example, I had a client, they were looking at the capacity limit for bars. And for most of the ones I looked at, it was, generally 30 or 40%. And it was, about 100 or, maybe 120 people.
So I was thinking large group gatherings, it was still 50.
It depends. So in some commercial establishments, I've seen it in large group gatherings. I think the differentiation is outside the commercial setting, if I remember correctly. I'd have to take a look back at the order. But so, for example, I was down in Athens the other weekend. I was picking up some furniture. My brother was moving. And we were walking by one of the bars that was open during the day, and there had to be, I don't know, I would say probably 100 people in there. And it was a big place, so they're all fairly spread out from what I could tell from the outside. But it seems for the most part, I haven't seen the 50 number being strictly followed, if that's actually the case. Anything else?
If anybody has a question, feel free to just unmute yourself. I think that would be completely fine if you want to follow up on anything that either Graham or Mel has said.
We'll be glad to take any questions.
Sure.
If you think of, drop us an email. We'll be glad to respond.
And this form, once I send out the presentation, obviously I'll send it out so Susan and Candace can distribute it. If you want other information, we have a legal alert list or a blog subscribe list. If you want to be added to that, just let us know and we'll be happy to get you on that as well. A lot of the information that we talk about today, that gets sent out. It's a firm-wide publication.
From what I was talking about, the bottom line is if you have more than one employee in group setting complain about something and engage in some sort of work stoppage, don't take any disciplinary action against them without getting counsel.
Okay, noted. Oh, well, I think that brings us to the end. Candace, you want me to bring it home still?
Yeah, and if you would cover a little bit about the video library that we're building and how that's going to be accessible.
Yeah, I'll take a moment now to explain where this Back to Business series is going to be going. First and foremost, they haven't joined us on the call today, but I do want to extend tremendous thanks to our friends at Delta Community Credit Union, who have so graciously offered to sponsor this program so that we can continue to offer it as a value to members. We're not focusing so much on those who may not be able to join us live or in real time as we're recording these sessions. Of course, we encourage you to do so and we love to see your faces. But our attention has turned more toward building a virtual library that our members can come back to again and again and again. They're free to share it. It's going to be accessible to the entire public, and it will also be woven into the fabric of our Advancing CWEDA and Connecting CWEDA properties respectively. So it's our goal to build that library, again, a touch point that you can come back to whenever you need to come back to it. And we look forward to the exciting topics that we're going to be covering between now and the end of the year.
And I want to say thank you again to our wonderful friends. Now they're a part of the Chamber family that have agreed. Are we going to do part 3? Graham and Mel?
We're up for it.
We're up for it. We're happy to.
Yeah. And I know we had one of our members reach out to you and you've been working with her on a new employee manual to reflect COVID. Is that correct?
That's right.
Yeah. So if anybody has any types of these types of legal needs, I know you've worked with us at the chamber on a new liability waiver for our volunteers and staff and others who come to an event or the building. And these are just basic things that we all need to reevaluate. So absolutely feel free to reach out to Graham and Mel for any kind of legal advice or information that you're looking for. They are the experts, right, gentlemen?
Thank you. I think by osmosis we've acquired a lot of this knowledge over so many years.
Mm.
Well, we're very appreciative. Thank you very much. We look forward to part 3. Maybe Susan, you could get folks to email you what they'd like to hear in part 3.
Sure. By all means, if there's an issue that you have faced that we haven't covered in either part 1 or part 2, please do feel free. It's easy. It's Susan@NoonanCowetachambers.org. Everybody, I think, on this call likely has that email address already. And you can also read a little bit more about part 1 in Thrive, in the forthcoming issue of Thrive, because we did take the information that was presented to us and translate it there as well.
Well, be safe. Thank you again for having us.
Thank you very much. You guys
Thank
have a
you.
wonderful day.
Thank you.
Thanks to everyone for joining.
Bye.